as well. Well, why is no one in the media talking about another group claiming that they too have been targeted by the IRS? The group is not a Tea Party group. Instead, it's a pro-Israeli group called Z Street. They were one of the first groups to sue the IRS back in 2010, putting the IRS on notice that because of that litigation, it had to, by law, retain all information that could conceivably lead to admissible evidence in court. Lori Lowenthal-Marcus is the president and founder of Z Street, and she joins me once again now. Lori, great to see you again. You've been on the show to talk about the fact that you believe you were targeted. You still have never received your 501c3 or 4 status. But what's explosive today is what's being written in the American Thinker. The Z Street case may be what forces the IRS to pull aside its carefully constructed curtain and reveal how it made decisions regarding organizations deemed out of step. How so, Lori?
Well, as you mentioned, Gretchen, we are the first organization that became aware that the government was dealing with applicants for tax-exempt status in a way that seemed to violate the Constitution, frankly. Because we found out back in July, of 2010 and filed our lawsuit in August of 2010, with the filing of that lawsuit, the government was under an obligation to retain all possible information, documents, emails, etc., that might give rise to admissible evidence in our case. Therefore, the government, the IRS specifically, was under an obligation to have what's called a litigation hold. They had to retain any information about how the IRS was processing applicants for tax-exempt status.
Yep.
And so when everyone learned that Lois Lerner's emails were lost, as were 6 other members of the IRS in her circle, they were already under an obligation to hold that stuff. They could not have then recycled the servers.
And that's what's so alarming and startling about your case that not a lot of people know about, is that they were already legally liable based on the fact that you had filed suit in August 2010. Now, if that documentation, any of it was destroyed, I mean, that's a federal crime, obviously. It's called willful spoliation, right?
Well, yes, obviously it has to be proven that it was done willfully, that they were aware of the litigation. But, you know, no matter where you go down the line, someone was aware and was under an obligation to inform the others in the government, in the IRS, and perhaps elsewhere, that all of this information had to be retained.
All right, so this is why your case, well, it's the same. Did we lose Lori? There she is. It's the same as the Tea Party because you believe you were targeted, but it's different because of when you filed your exact lawsuit. Now, what is going to happen with regard to this discovery phase of your lawsuit right now?
Okay, so we entered the discovery phase once the government finally answered our complaint. It took 4 years for them to answer. And we started the discovery phase. We have our first conference where we speak with Z Street's lawyers and the IRS lawyers at the Department of Justice, have a conference call on Friday where they discuss the parameters of discovery and the timing. And then on August 12th, the parties meet with the judge in Washington to talk about those issues. So really, we're about to start bringing on the documents, the requests for information, the depositions of the relevant officials involved.
Yeah, it'll be very interesting. Please keep us posted on those 2 dates, August 12th, of course, being central to that. Lori, thanks for your time again.